Hi everybody, April Jones here. I have been an attorney now over 33 years, and Jones Law Firm has been serving clients in Colorado, and we are in our 24th year. This webinar series, I'm so excited to bring it to you. It's helping us with our mission of education, enlightening our clients, and really helping you try to get to the next best place in your life. So we've got a lot of good information for you. We've got experts, we've got our team, we've got panel discussions, and so much more. So let's go see what this webinar is about, and I will see you on the other side.
Good afternoon and welcome to the Jones Law Firm webinar on changing your court orders regarding family parenting time and other issues. Modifying a court's orders in Colorado is possible and something we do on a regular basis at Jones Law Firm. Good afternoon. My name is David Collins. I am Senior Mentor Attorney at Jones Law Firm, and I have been practicing law for 20 years, exclusively family law for the last 8. I do divorce, allocation of parental responsibilities, grandparent visitation rights, guardianship, all manner of modification of existing orders. With me today are 2 of my fellow attorneys at the firm. Morgan, would you like to introduce yourself?
Sure. Hi, everyone. My name is Morgan Terrell. I am another one of the attorneys at Jones Law Firm. I am a senior attorney. I've been practicing for 10 years now, exclusively family law for the last 3.5. And before that, I did criminal law.
And Sarah, would you like to introduce yourself?
Yes, my name is Sarah Kroll. I'm a senior attorney at the Jones Law Firm, and I've been doing family law for the last 8 years.
Thank you, Sarah. And for those who have joined the webinar today, we're going to be providing a high-level overview of modifying court orders and the process and steps to get that done and what can be modified. We do encourage you to reach out to our office and schedule a consultation to learn more about your case. We'd be happy to speak with you and help you resolve the issues that you're having. The starting point for today's conversation is really that you already have orders. And so before we talk about having orders already, I'll just run through how you would have orders already. If you are married to somebody in Colorado and you file for divorce, at the end of that case, you will have orders regarding dividing your assets and debts, dissolving the marriage. And if you have children, there'll be an order regarding parenting time. Those orders can come either through agreement of the parties, or if the parties don't agree, the court can hold a hearing and ultimately make orders for the parties regarding dividing assets and debts and regarding parenting time, child support, and monthly maintenance payments. If parties aren't married in Colorado and they have children, either party can file an allocation for parental responsibilities, in which the court would then address how to divide parenting time and decision-making, and also make orders for child support. Once parties have those types of orders in place, over time, they often come back to court to modify those orders. And so today, that's the topic is, I have orders in place. What do I need to do to modify them? And there are several types of orders that you can modify. And so we'll walk through each one. Morgan, can you describe what it would be involved with modifying parenting time orders?
Absolutely. So we, like David said, we often have clients who come in and situations change with kids or with families or with living arrangements. All kinds of things arise over the years. We do our best to try and get you a parenting plan that's going to last you for as long as possible, but sometimes things need to change. And so when that's the case, what we first want to look at is what type of modification we're doing and when the last modification was, if there was one. So if there already was some kind of order put into place regarding parenting time, visitation, specifically, we need to look at how long it's been since those orders went into place. The statute specifically specifies that if we're just looking at changing parenting time, visitation, generally when the kids are with whoever or whichever parent, 2 years has had to elapse between the last modification and whatever modification you're currently seeking. So the courts will essentially time bar you if it's been fewer than 2 years since you last modified your parenting plan. There are some exceptions to that. The biggest one being that if the modification you're requesting is based on the endangerment of the children, the court will use the sort of the endangerment analysis, and they will take a look at modifying parenting time or visitation before that 2 years has elapsed since the last modification.
Thank you, Morgan. And I just add to that that we actually get a fair amount of cases where one parent has decided to move out of state and the court needs to enter a two-state parenting plan. In that case, the law in Colorado requires that a motion be filed to relocate the children out of state. The parties can agree on a two-state parenting plan, or the court can enter orders following a hearing. And that's a really common type of parenting time modification that we see. I should also mention that we have a chat available here in the Zoom, and if you want to enter questions that you'd like answers to the degree that we can, we will answer them. And we'll also just keep moving forward with questions we've pre-prepared for today's webinar. Sarah, can child support orders be modified? And if so, how do you do it?
Yes, absolutely. And there's really two different ways that you can modify your child support orders, either going through the court that issued those orders, going through the domestic relations court and asking that the child support be modified, or you can call the child support enforcement agency. And a lot of times they can help you out administratively without going directly to the courts. So I always recommend starting with child support enforcement to see if they can help you out, or you can file your motion to modify child support directly with the domestic relations courts that issued that order.
And Sarah, a follow-up question for you on that. If two parties are going to modify child support, what do they need to provide to each other in order to be able to reach a new calculation?
So they'll have to provide updated statements on their income, their monthly pay stubs, and their tax returns to show how much money they're making and see if that changes the child support calculation based on what parenting time they have and how much they're making each month.
And one item we should mention now is that anytime you file a motion to modify the court's orders in Colorado, the court almost always will require the parties to attend mediation first before they ever get a hearing in front of a judge. And that's because the vast majority of issues are actually resolved at mediation in Colorado, and it saves the parties a lot of time and money to settle at mediation if they're able to do that. Morgan, can you tell everyone what mediation is and how it works?
Sure. Mediation, like David said, is required usually in all of the cases where we don't already have an agreement between the parties. And mediation is usually attended just like we're attending today, so via Zoom or some other electronic means. So you don't have to be in the same place with the other party in most of the circumstances. But essentially what the parties are going to do is choose who they want to use as a mediator. We have lots of good options in Colorado, and the parties will try to agree on who to use as a mediator. And this mediator is an independent third party who's not related to anything with regards to the case. And these are people who oftentimes are recognized by the court, either through the Office of Dispute Resolution, or we have a great selection of private mediators as well that we can use. And essentially what the courts are trying to do is have somebody who's not interested in the case, not a party to the case, try and help the parties reach some sort of agreement. And they'll ask you, difficult questions, both parties, they'll ask you, have you thought about this? Have you thought about that? And really try and facilitate a conversation between the parties to try and reach some sort of cooperative idea, or I'm sorry, to reach some sort of agreement on parenting time or any kind of modification that you're looking for. And then if the parties do agree, the mediator will then help you draft up your agreement, and you can submit that to the court. And so this is a way that courts try and give the parties more control over what happens with their cases. And parties generally are happier with the outcomes when they have more control through processes like mediation versus going to a contested hearing.
Thank you, Morgan. I'm going to pull a question from the chat and I'll answer this one. The question is, can the parties modify that part of their child support order regarding health insurance and covering the children on health insurance? That's a great question. In every case that I've been a part of, the court orders one party or the other to carry health insurance for the children if one of the parties has work-provided health insurance. There are cases we have where the children receive Medicaid, and the court just orders that they keep getting that if they're eligible. But the question in front of me today is, if I'm ordered to pay health insurance and my ability to provide that changes, or I just need to change who's providing insurance, can I do that? The answer is yes. You can ask the court to change who is providing health insurance for the children. In general, on all child support worksheets, the party paying for health insurance is credited for making that payment on the child support worksheet, and the court ultimately apportions the cost of that health insurance to each party based on their income, in proportion to income on the child support worksheet. But if one party has been ordered to pay the insurance or ordered to keep it because they had it through an employer and lose it, you can certainly ask the court to modify that to change the requirement for who pays for the insurance. It doesn't mean the court will necessarily relieve the parent from contributing to the cost of the insurance, but they can relieve the parent from carrying the insurance if there's a cheaper, more efficient alternative insurance opportunity for the children. Sarah, the next question I have is, what about maintenance? Can maintenance in Colorado be divided? For those listening, maintenance may sound like a foreign word. A lot of us grew up hearing the word alimony. Maintenance is basically the same word in Colorado. It is a monthly payment from one spouse to another following the entry of the decree for some period of time. It's meant to prevent the party receiving it from hitting a financial cliff the day the decree enters. Oftentimes in our caseload, one party has been the breadwinner for the entire marriage, the other has been a homemaker, often by mutual agreement, and it's not always gender specific. A lot of our breadwinners are moms, and dad is a stay-at-home parent, but the court will fashion a maintenance order so that the parent who hasn't been working during the marriage doesn't hit a financial cliff. When the decree is entered, they have some level of support to carry on their standard of living for some period of time. The question is, Sarah, can that order be modified?
Yes, absolutely. If there's been a change in either your or your ex's income over since the divorce, that can be modified. If there's been a change in your income, that can be modified. If there's been a change in if you're working or not, if there's been substantial changes to your financial, the availability you have to, I'm sorry, what am I trying to say? The financial resources you have available to you. Maybe you're getting more support from another party or from your family, or if you're become disabled since your divorce. Those are all reasons that could affect the spousal support, and that you can ask to have that spousal support modified.
Thank you, Sarah. And I think you mentioned this, but maintenance can be ordered two ways in Colorado. If the parties enter an agreement in mediation or before going to a hearing, the court can adopt that agreement and follow those maintenance agreements, or the court will hold a hearing dissolving the marriage, and at that hearing take evidence and testimony and enter a maintenance order. The reason I bring that up is often if parties have negotiated an agreement regarding maintenance, they also might agree that the maintenance agreement is not modifiable. And if the parties enter an agreement that the maintenance is not modifiable, it can be almost impossible to change that particular maintenance order because the statute says if the parties agree it's not modifiable, the court won't modify it. And so it's really important to understand, if you're in a position to receive maintenance, you may not, if you're in a position where you're going to pay maintenance, you may not want to agree that it's not modifiable, because you may not be able to sustain those payments for the period of maintenance. I have a client, or I had one recently, who had a period of maintenance of 10 years at $3,000 a month. And 5 years into it, he became disabled and couldn't really make the maintenance payment anymore. His maintenance agreement was not, there was no clause in the agreement preventing modification, so he could file a motion with the court to at least attempt to modify the maintenance based on his changed circumstances that made it unrealistic for him to continue paying. I'm going to take a question from the chat here. It's a two-part question, so I'll answer both parts. The first one is, can there be mediation when there was domestic violence? The answer is yes, but it doesn't have to be. So in Colorado, if a party has been a victim of domestic violence, they can ask the court to waive the mediation requirement so that you don't have to mediate with the perpetrator of domestic violence, and the court can grant that motion. There's a plus and a negative to that. In modern mediation, you're never in the same room as the other party. You're usually in the room alone or with your attorney, and the mediator either moves back and forth in virtual rooms or at their office, and you're in one office with your attorney and they're in another office, you never cross paths. The reason I don't always encourage my clients to waive mediation, even if they could, is because they might be able to settle and not incur a lot of attorney's fees going to hearing because they didn't mediate. If you don't mediate, you are almost certainly going to go to hearing unless you can circulate a separation agreement, which is basically mediation without a mediator, and reach an agreement on everything. But the answer is yes. You can ask the court to waive the mediation requirement if you've been the victim of domestic violence, and the court can waive that requirement. And I've done that in my caseload a bunch. The other question is there a time limit before you can modify child support? The answer is no. In Colorado, anytime there is a likely 10% change in child support, a party can file to modify child support in Colorado. For example, if you are receiving $500 a month in child support and it would go up or down $50.01, which is 10%, you would be able to file for a modification of child support. And things change dramatically during the period of child support, especially if you have a child who is, say, 2 years old when you get the order, and you have two young parents, and 7 or 8 years later, they're both working professionals and their incomes have gone up, or one's gone up and one hasn't. There could be a significant change to child support. You can also change child support based on a change in custody, even if it is not court ordered. If the parties informally mutually agreed that instead of being 50-50, it was going to be more like 70-30, that would be a basis to modify child support. And the reason is you would tell the court is by mutual agreement, the parenting time schedule has changed, and therefore child support should be modified as well. And the reason for that in that fact scenario is that the number one driver in child support calculation is the number of overnights the child is with each parent. On a 50-50 schedule, that's 182.5 nights. As the schedule changes, it really moves the needle on how much child support is paid. The second most important factor is the actual monthly income of each parent. And so if either one of those, the incomes or the overnights change, you likely have a basis to modify child support. Also worth noting that the parties cannot agree not to modify child support. Even if you put it in writing and sign it that you guys will never modify child support, it is not enforceable. The court in Colorado always retains jurisdiction to modify child support, and the parties actually cannot agree to suspend their ability to modify child support. Morgan, I'm going to throw this next question out to you. The question is, if I want to file, and I'm paraphrasing the question here for those folks who wrote it, but if I want to move out of state and file a motion to relocate, how long does that take? And if the parties agree on the relocation, does that speed things up?
Absolutely. Anytime the parties can reach any sort of agreement, it's going to speed things up. Typically, what we see in our practice is that the cases that take longer are the cases that are very contentious, the other party's very litigious. That takes longer with the court. It takes you a longer time to get into mediation. It takes you a longer time to get set for a hearing. That's always going to drag the process out. The courts are not known for their expediency or their efficiency. And so you have to think about that when you're trying to resolve a case. And of course, anytime that you can reach an agreement, that's going to move things through quicker. We can't really tell you how long it's going to take to file any sort of relocation. It really just depends on if you guys have an agreement. But if you guys do agree and can agree on what a two-state parenting plan is going to look like, you can file that with the court as soon as you have an agreement, and the court will adopt it. The court always is happy to sign off on agreements where both parties have come together and been able to cooperate and figure out what's best for the children and what that's going to look like. So the court, as long as there's nothing in the agreement that's unfair to either party, the court's going to approve that, and you guys will be free to do your relocation.
Thank you. And I would just add to that if there is a motion to relocate, that is definitely going to change the parenting plan if it was 50-50 to something dramatically less. In a two-state parenting plan, the primary parent basically has the child during the school year because they have to go to school every day. And the parent who's not the primary will get parts of major school vacations and often big chunks of summer. The reason I bring that up is that also will likely lead to a modification of child support. So if you're agreeing to modify parenting time to a relocation to a two-state parenting plan, it's also a good idea to modify child support at the same time. Another question coming in here that I will throw out to you, Sarah. If I agreed, and again, I'm paraphrasing here, if I agreed to child support at $600 a month because I needed to get the deal done last year, but I know that child support should be higher, can I file to modify?
So in that situation, there would still need to be the 10% change in income to qualify your case to modify the child support. So if there's been a change in income between you or the other party, then yes, you can ask that child support be modified and that the correct amount from the child support worksheet be considered.
And I'll just follow up on that. It's actually and just to correct, it's a 10% change in the child support payment. So on a $600 payment, the change would need to be $60. And it doesn't actually require that the incomes have changed. But in order to file the motion, I would invoke the statute. There's a statute in Colorado in the child support law that says every year the parties must exchange, upon request, their tax returns. And so every year, usually between April and May, parties can ask each other for their tax returns. That would give you the current income, even if it didn't change. It'd be helpful to have the current income to put in your motion to say, here's the income today, here's the child support payment today, and based on using the state's calculator, that there would be a 10% change. So court, please entertain this motion to modify child support. The next, I'm going to pull, Morgan, I'll pull another question off the from the chat here. This is a good question. So this is another relocation question. If I want to move out of state, do I have to provide a reason why? Can the court reject the move if there are no valid reasons?
Yeah, that's a great question, and one that we see quite frequently. So the short answer is yes, that the court can reject that. The court is going to take a lot of factors into consideration when thinking about its ruling on a relocation. And one of the things that the court is going to look at is the reasons for the move, and is that going to be in the best interest of the children, right? Especially if the opposing party is asking to be the primary parent out of state, for example. The court would have to look at, okay, well, now we have the kids leaving their communities, leaving their schools, leaving their group of friends, perhaps leaving extended relatives, and things like that. And so the court is going to take into account all of both parties' reasons, either the party for staying, who wants the kids to stay in Colorado and wants to remain in Colorado, and also the parent who wants to relocate. And so I think the more reasons you can give, obviously that's going to strengthen your argument or the argument of the other party. But I think a court would be less inclined to grant a relocation without some sort of substantive reason of why the relocation is happening.
Thank you, Morgan. And I'll just add to that, that if a motion to relocate is filed, the court has to assume the parent who filed it is moving. And so they'll fashion a two-state parenting plan, even if that means the children stay in Colorado. So often a parent who's relocating files the motion to relocate because they want to take the children to Nevada, Florida, Georgia. I mean, we have them all over the country. But the court has to assume the parent's moving, even if the kids don't go with them. And so there's no guarantee you win the relocation, but you may. But Morgan's right, the court has to apply what's called the best interest of the child standards, which is its own statute in Colorado. And when you combine it with the rest of modification statutes, there are about 19 criteria that the court will apply if you have a hearing to sort out what is in the best interest of the children with regard to relocation. If the parties agree on relocation, you save yourself all of that work. But it's not always the case that parties agree. The next question I will throw out to you, Sarah. Actually, I'll answer this one, and then I'll give you another one, Sarah. The question is, can I ask the court to change my children's last names from one parent's name to be hyphenated? The answer is yes. It doesn't mean it's guaranteed to happen. I've had several cases, though, where motions were filed to change the child's last name. The court did grant it, and the court did grant hyphenated names. There's no guarantee the court will grant it. There's no guarantee what the outcome of the last name will be. I've had clients who absolutely wanted the child's last name changed from the other side's last name to their last name, I haven't seen a lot of success with that. I've seen more success with a hyphenated name where the child becomes has the last name of both parents. But there are actually, yes, there are forms and a process to follow to ask the court to change the last name of the children. Sarah, this is a great nuanced question because and I agree with the person who wrote the question, is this a relocation? My ex relocated in Colorado, but 70 miles away from my home. Can the court treat that as a relocation if it's affecting parenting time and quality with the children?
Right, absolutely. If it's affecting the parenting time, then that's considered a relocation. If you're having to drive 70 miles to parenting time, that's going to reduce the amount of time that the kids are actually with you. That's going to affect your ability to have parenting time and how often either parent can have parenting time because of how far apart they live. So that would be considered a relocation.
And I agree. And I would say we often get it where one party relocates to Durango or Mesa, but it doesn't actually even have to be that far. It's enough to disrupt the nature of the balance of parenting time and putting yourself in a car, basically for 3 hours, depending on where you are in Colorado for the round trip is a lot of time in the car. Morgan, I'm going to throw this question at you. I think we're almost out of time, but we'll just keep answering questions till we run out. I am wanting to move out of state because of domestic violence. And so we've kind of answered this question already on relocation. I'll just answer this and say the domestic violence won't necessarily be a factor in whether you can relocate. A relocation will be treated as a standard relocation. And the court will have to decide it's in the best interest of the children to allow them to leave the state. Morgan, I'll throw this question to you. If you live with the other parent, I guess the question, it's a broader question of, there are some specific facts in this question, but is there a length of time you have to be married to be eligible for maintenance?
Yeah, that's a great question. One we get all the time. The answer is no. Any length of marriage can result in a request for maintenance or alimony. The court does have several factors that it will take into account when looking at a maintenance payment. And one is the length of the marriage. And typically the guidelines that the court uses is parties have to be married for a minimum of 3 years, but that's certainly not a black and white sort of timeline. You don't have to be married for 3 years. You can certainly be married for fewer than 3 years and still request maintenance. But the court essentially has a long list of factors that it's going to take into consideration when awarding maintenance. The length of the marriage is just one factor that they're going to consider.
Thank you, Morgan. And from the question, I can't really tell if the parties are married. It references living together. And if you're not married, no, you're only entitled to maintenance if you're married. However, you can be common law married in Colorado, and we have plenty of cases where we established that there is a common law marriage. Too complicated for today's webinar, probably its own standalone webinar, but maintenance is only available to people who are married either legally or through common law marriage. The last question here, can maintenance payments be added after final orders? No, generally not. The court will make, if you are at a final hearing and the court enters final orders to enter your decree, the maintenance order must occur as part of that final orders and be entered as part of the decree. So if you're fully divorced and you agree to no maintenance or the court didn't order it, there's not a way to revisit it. Usually if you've settled your case without a court hearing, you've settled it with a document that says we are waiving maintenance. And usually that provision would also say we are waiving it forever. And so that also would prevent the parties from coming back. Folks, we are out of time. We're glad you could join us today. We will be hosting more webinars in the future. Please give us a call if you have more questions. We'd be happy to do a consult here at Jones Law Firm. Thank you and have a great day.
Hi, welcome back. I hope you enjoyed this episode of our webinar series. You can reach us at denverdivorceattorneys.com. You can call us at 303-799-8155. We're on Instagram, Facebook, Twitter, TikTok, LinkedIn. You can find us if you need us, and we're here to help. Thank you and see you next time.